Good morning, everyone. We're about to start our webinar this morning. I'm just going to give everybody another 15 seconds to dial in. Fantastic. I can see that many of you are still joining, but we're going to start promptly. Good morning, everyone. My name is Lana Pavlian. I'm the Chief Compliance Officer for the Ras Al Khaimah Free Zones, looking after the anti-money laundering, counter-financing and terrorism regulations implementation. Today, we are going to run a very interesting webinar for you. And Ibtisam, who is a partner with Al-Tamimi, and she looks after financial crime for Al-Tamimi and actually represents a very interesting industry group as well that she will tell you more about later. She's joining us today to talk to you about the different requirements that are applicable to the designated non-financial businesses and professions. All of you on the webinar this morning are categorized as DNFBPs, and that would be precious metals entities, corporate services providers, accountants, lawyers, notaries, and various other professions. You have been categorized as DNFBP and categorized as actually in scope of the anti-money laundering regulations because of your position as trusted advisors and your ability to actually knowingly or unknowingly facilitate movement of proceeds of crime. UAE are under a rigorous process of review and reassessment by the FATF, the international body that came into the UAE 2 years ago to review our effectiveness on implementation of anti-money laundering and terrorism financing controls. We have another assessment coming up in October. Hence, we are talking to all of you today to ensure that you are aware of your obligations under the applicable regulations and that you help the UAE meet the effectiveness standards that are expected by the FATF. Ibtisam is going to talk you through the regulations. We're also going to discuss the CDD requirements and the requirements that are applicable to you in terms of identification of the ultimate beneficial ownership of your entities. And then Alan, who is our registrar at the RAC International Corporate Center, will close the webinar by discussing the expectations that we have as authorities and the process of enforcement and supervision of DNFBPs that we have put in place. Without further ado, Ibtisam, over to you. And thank you, everybody, for joining this morning.
Thank you very much, Lana. Hello, everyone. Assalamu alaikum. I'm pleased to be here today, and thank you for joining. It's very nice meeting you all virtually again, but thank you, Lana, for the introduction. So as Lana mentioned, my name is Ibtisam Laswad. I'm a partner in the regional financial crime practice at Al-Tamimi and Company. In addition to that, I wear a second hat, my night shifts, and it's one that is called the Global Coalition to Fight Financial Crime, MENA chapter. I have been appointed as the chair. I'll come back to that if we have some time at the very end, okay? But before we get into the substantive topic, I want to preface the session today by saying that AML is a very technical subject. And whilst I could, of course, spend several hours walking you through the various provisions of the law and the specific corresponding parts of the policies that you are required to follow, eventually, we do not have time to cover everything today, so I will be cherry picking the highlights, so to speak, okay? So generally speaking, AML legislation is about ensuring that there is an adequate network of controls and information sharing that will allow the authorities to detect and prevent flows of illicit funds through the financial system. So while there are, of course, the provisions that relate to the independent and predicate offenses of money laundering and the like, the majority of the legislation and the supporting instruments are dedicated to telling practitioners how and when they are actually obligated to implement the system of controls, okay? So as a result, the most effective way to train on AML is, in my opinion, to look at how the various basic elements of the control framework are implemented in practice, what they may look like to practitioners on the front line and on the ground, and what problems can occur at various stages, okay? So let me first start with giving you some kind of overview. I mean, in addition to what Lana has mentioned, but the current context, current AML context in the UAE, and Joanna, if you could put the slide. So here, it is important that we cover the next one, yeah. Okay, so it is important that we cover a small amount of context before we get into the minutiae of AML compliance. So one of the driving forces that we see in AML reform across the Middle East region is the role of the Financial Action Task Force, or FATF, which is the international watchdog for AML and counter-terrorism financing matters. So, and it is responsible for setting international standards and recommendations for defensive measures. So the regional style body for the Middle East and North Africa, known as the MENA FATF, is then responsible for assessing each country in the region. So grading its compliance in terms of technical alignment with the recommendations, but also its effectiveness in actually preventing money laundering, terrorism financing, and sanctionable activity. So what does it mean in practice? When the mutual evaluation reports are published for each country, they act as leading sources for international reference on the strength of defenses that are applied to a national financial system. So by this, I mean that if you look at, I mean, people trying to enter into the market in terms of looking into doing business in this part of the world, in any of the countries where we operate, they would look at the mutual evaluation reports, amongst other things, of course, like ease of doing business, like reports that are published by the World Bank, etc. But that's a very important metric that is used by actors from all around the world to inform their commercial, political, and economic policies as well, from international funding packages as well. It's not just about, it's even for, like, you know, international organizations and whether or not they want to participate or help a country, basically, when we are talking about developing countries, for example, or more something like investment strategies for private equity. So the level, what I'm trying to tell you here is that the level of influence that FATF assessments can have for countries has increased also the visibility of AML matters. And of course, it has pushed, by definition, has pushed this to the forefront of the policy agenda. So when it comes to the UAE FATF report, it was published, as you know, in April 2020, and it gave mixed reviews. So although the report acknowledged that significant improvements were made since the UAE's previous report in 2008, and highlighted also some strong areas of technical compliance within the legislation, ultimately the findings showed that there was a need for the UAE authorities to focus on improving the effectiveness of the AML defenses. So of course, this has given rise to a number of downstream measures implemented by the UAE authorities, so-called because they focus on ensuring that the relevant parts of the AML system infrastructure, including private sector, public sectors, regulators, supervisors, and even law enforcement, are working cohesively to support every part of the AML defense system. So these measures include the recent increased engagement with the private sector, through training sessions and workshops, and I'm sure you have been taking, hopefully, part to these various trainings and workshops, and also the mandatory registration on the GoAML portal for all offshore DNFBPs to submit suspicious transaction reports, STRs, and the creation also of a unified register for ultimate beneficial owners, to improve corporate transparency. We'll come back to these points in greater detail at a later stage, but in the training. So I just don't want to focus too much at this point, but I wanted to mention them here to give you a sense of how the authorities are treating AML as a policy priority and are devoting significant resources to reinforcing the defensive system. Okay, this is also reflected in the increased enforcement environment with the supervisory bodies such as the UAE Central Bank, the Ministry of Economy, and the Ministry of Justice, all taking steps over the last several months that clearly show their willingness to leverage the powers that have been given to drive compliance with the AML law. So this comes in various forms, whether it is fines that are applied to exchange houses for AML failings, or the mass temporary suspension of commercial licenses for non-compliance. And this has also applied to law firms at one stage. So companies need to be aware that enforcement actions are a real possibility, and the price for failing to take these obligations seriously can be commercially catastrophic. Okay, so we'll move to the next slide, please, Joe. And here I'll briefly go over the outline of the UAE AML system so that you can get a sense of where the main provisions are located. I mean, although hopefully you are already very familiar with those, and I want to draw your attention to how the relevant obligations are filtered down through the supervisory bodies and other regulators to the different parts of the UAE's economy. So if you look at the screen, the primary pieces of legislation that you need to be aware of are Federal Decree number 20 of 2018 on anti-money laundering, counter-terrorism financing, and financing of illegal organizations, AML law, and the Cabinet Decision number 10 of 2019 concerning the implementing regulations of the anti-money laundering law, the AML implementing regulations. Okay, collectively, the AML legislation contains the bones of the UAE's AML framework, including the main requirements that regulated institutions need to follow to ensure that their internal compliance programs are in line with international recommendations. So just to give you a few specific examples here, at the time when the new AML legislation was introduced, it brought many reinforcements to the AML system, including higher penalties available to the authorities to prosecute offenses, a broader range of powers available to authorities to cooperate with their international counterparts, and financial institutions and DNFBBs are required to take risk-based approaches in line with the threats which were included within the national risks assessment, so that there is broader awareness and better management also of money laundering and terrorism financing risks. Okay, and so here, one point to add is that whilst these may seem like minor revisions in isolated context, the combined impact of these changes is a much more robust level of defense against financial crime and a more sophisticated capacity for the authorities to detect and prevent the illicit flows of funds. So critically, the AML legislation operates at the federal level, meaning that it is directly applicable to all UAE-based entities, including those registered in free zones. Although each free zone is regulated by a different supervisory body, and many are subject also to separate regulations imposed by the relevant oversight bodies, all regulations should be understood in a broad sense to be implementing tools for the federal provisions and should be read in conjunction with the AML legislation. So, flowing from the AML legislation, there are many additional circulars and regulations that have been passed by the authorities to also augment or clarify different parts of the framework. So this includes procedures to be followed relating to the designation and delisting of terrorist organizations and other sanctioned entities, economic substance requirement, dormant account regulations, but also various other guidance issued by the relevant regulators. So since the guidance and circulars are typically communicated by the supervisory bodies to the specific sectors that are under their guidance, these are comparable to the policies and regulations that are imposed by the RAKEZ authority to RAKEZ registered companies, okay? So I would like now to take you through one very specific point, which is a very relevant one. And it's the special case of free zones. On the next slide. So the UAE, as you would know, is commonly accused by international bodies of being a global hub for money laundering activity. And one of the main concerns that is cited as the basis for this criticism is the prevalent use of free zones. So at the time of its FATF assessment, the UAE had 2 financial free zones and 29 commercial free zones, which clearly has benefits, but it comes at a cost from a financial crime perspective. So the different regulatory systems creates, of course, a fragmented supervision structure that exhibits different levels of AML protection in different sectors and areas, and leaves certain part of the economy exposed to additional abuse by criminal actors. The FATF had identified free zones also as providing attractive opportunities to money launderers due to the opportunities they bring for duty and tax exemptions, streamlined administrative processes, and concentrated import-export activity under reduced supervision. So as a result, and as you would know, and probably I'm sure you have heard, free zones are commonly linked with increased fraud activity, trade-based financial crime, and transshipment also of dual-use products that are subject to sanctions restrictions, amongst other associated issues. So this is something also that I can confirm from my based on my own experience, and I cannot tell you how many times or how many of our cases actually have involved a free zone entity, sometimes based in Iraq and sometimes elsewhere, and where the benefits of establishing and using an offshore entity as a conduit for international trade and financial flows has been abused by criminals. And of course, it is very important. The reason why I'm mentioning this today is that you have seen tremendous efforts, as I mentioned, led by the UAE authorities, and of course for each and every free zones and also Emirates. This is something that has been at the top of the agenda, and I know, of course, that Ras Al Khaimah has been working very hard and has made like tremendous efforts to upgrade and make sure that those like to break the stereotypes as well, because whilst there are situations where we have faced or we have had one companies or another based in a free zone, this is not only applicable to the UAE, and also, as you can see from those the few examples I have listed here, it's very important that as practitioners operating in this part of the world and in the UAE in particular, we also help the authorities to elevate the perception, the vision, and the actual the practical side of things, to make sure that people understand that it is really a zero tolerance policy, and that's something that is being taken very seriously by everyone. As I said, this is a recurring feature of various methodologies that we have seen, but it's not exclusive to just one form of financial crime. We have seen, I mean, in different instances also situations where free zone entities were used to launder funds from major foreign corrupt offenses, or hide assets through some kind of fraud schemes, etc., or having like intermediary vendors of goods that are subject to international sanctions. So again, the reason why I insist on this point is to reinforce the particular importance of the free zone entities being aware of the risks and maintaining even greater vigilance when it comes to implementing AML defenses. So with that, of course, there's always the debate as to willing to, remaining competitive, but at the same time ensuring that you comply with the relevant laws and regulations. And it's also our respective duty to make sure that we assist with that. So the bottom line is that free zone entities, in terms of the model, the UAE model, and the UAE's commercial ecosystem, they are an important part of that commercial ecosystem. But as I said, their role in enhancing business comes with corresponding responsibility for all registered companies to fully abide by the regulations and support the efforts of the authorities to make the UAE a safe and internationally renowned place to do business. Okay, so I'll move to the next slide. And now, looking at the system from a macro perspective, the first relevant thing to understand is how the various parts of the AML system functions and how they fit together to create a defensive system against flows of illegal funds. So at its very core, the AML system can be boiled down to identifying and understanding your clients, assessing their risk for money laundering factors, and wherever relevant, sharing this intelligence with the regulators and law enforcement agencies so that they can understand how criminals are actually exploiting the system, prevent the abuse, and enforce the law against the perpetrators. Okay, so of course this is a very rudimentary summary, and part of the perpetual dialectic with the AML system is that this is a lot more complicated to do in practice than it sounds. Okay, the point here that I want to emphasize is that the AML defense system is ultimately one of a mutual reliance for public authorities and private entities. So, and of course, as I said, if the obligations are not met on either side of the equation, then the system falls apart and its utility is completely diminished. Okay, so the more effective the private institutions are at collecting the relevant information and feeding that back to the authorities as part of their reporting obligations in the form of actionable intelligence for law enforcement to pursue, the more likely the system is to be effective in reducing those risks to the private institutions. Okay, so needless to say, when you then add all of the other variables to the compliance environment, such as the risk-based assessment, the record keeping requirement, and all of the other various components, things become more difficult. But the circular value proposition, however, is still a defining premise of how the system is supposed to work and should form the underlying creed of every compliance program. So the reason why I make this distinction here is because the recent trend is towards the tick box approach, where compliance obligations are carried out simply to obey the regulations and without necessarily, considering the purpose of the system. So generally speaking, taking a risk avoidance approach or over-reporting for the sake of discharging an obligation is not good compliance. Let's be very clear about that, because it overburdens the system and significantly reduces the utility of the system, So what we are aiming for is sensible and sensitive implementation rather than blanket and automatic adherence to the rules. So let's go to the core pillars and best practice. Thank you, Joe. So now that you have this general understanding of the shape and context of the UAE's AML defenses and the recent reform, I will pivot here to address things from a more practical angle instead of a theoretical one, okay? So if you look at RACE's registered entities, they are obliged to follow the policies and guidance set by the RACE's authority, which imposes the framework of AML controls from the federal AML law and the implementing regulations. So the RACE's Corporate Service Provider Regulations 2020 contain the main commitments for corporate service providers to understand and abide by under the RACE's AML, CTF, and sanctions policy, in line with the commitment of the authority to protect the use of the free zone. So the requirements of the RACE's AML, CTF, and sanctions policy relate to the ability of the authority to conduct ongoing monitoring of its clients, including understanding the nature of its business activity, its beneficial ownership, the customer due diligence, and the sanctions restrictions. So each of these elements echo the same obligations that entities carrying out restricted activities must also undertake as part of their compliance, their own compliance programs. Okay, so I will explain the rationale as we work through the core pillars of an AML compliance program. So hopefully it becomes clear both why you have to collect and provide this information in the context of compliance. So the first point is about identifying DNFBPs. So getting right to it, identifying which companies are required to implement a full complement of AML control is the first consideration for establishing a compliance program, okay? So as I mentioned earlier, aside from financial institutions, the DNFBPs are the main cohort of companies that make up the private sector side of the AML defense system. So DNFBPs are also known as gatekeeper industries, so-called because of the role they play in business practice, which is typically connected to the acquisition of a high-value assets or to the recording also and reporting of financial performance and assets. So speaking from the federal perspective, and so although the legislation provides for clear categories for DNFBPs, these categories are exceptionally broad and are clearly intended to capture a certain type of activity rather than a certain type of company. So it would be impossible for the authorities to provide, an exhaustive list of every type of activity that is intended to be caught by the regulation. So the companies really need to assess their respective activities to determine whether they would be caught by the purpose of the law. So it may be the case that the type of activity that a company is conducting, whilst they are not technically classified as DNFBPs, are nonetheless carrying out DNFBP's activity and are, as such, incurring all of the AML risks that the control systems are designed to prevent. So in previous cases, we have seen instances where updates to the legislation have actually brought some resistance from the market and reluctance among some companies to subject themselves to the requirements of the AML law. While there are some clear-cut cases, such as the inclusion of law firms and auditors, things tend to become more ambiguous when it comes to industries that typically involve diversified businesses with some intersection with regulated activity. So let me give you a very clear example, I think. The real estate sector, it's a prime example of this. Although the law refers to brokers, the underlying activity that is intended to be caught is involvement in buying and selling of property. So where the same activity is carried out, but the company does not exclusively act as a broker, the regulations may still apply. So this is clear in this legislation, as a provision actually is added to state that further categories of DNFBPs can be added to the list at the recommendation of the National Anti-Money Laundering and Terrorist Financing Committee, subject to the risks identified. So this flexibility allows room for the addition of businesses that are exposed to similar AML risk. We will look at another very specific item, which is the precious metal and stones dealers, which is also problematic. Because if you look at luxury brands, they often find themselves unsure, and I have experienced this with some of our clients. They are unsure of whether a small percentage of their business is actually sufficient to bring them within the scope of the definition of the DNFBP. So of course, we also look at a very important point here to mention the non-profit organizations, which are included within the scope of DNFBPs. And despite the controversy that this attracts, the risk of criminal abuse to non-profit organizations, particularly when it comes to terrorism financing, is significant. So this protection against abuse of humanitarian intent is vital. If I go back now to the dynamic that I mentioned before about RACE's authority implementing the same shape of federal AML legislation, the authority also imposes additional AML obligations on DNFBPs, which it defines in its DNFBP regulations. So I won't cover the entire article here, but I want to draw your attention to point 4, which expands the scope of DNFBPs to include providers of certain corporate services and trusts that perform or execute a transaction on behalf of their customers relating to specific activities. This is the most relevant article for most of our attendees today. So these activities all relate to services that could potentially allow RACE's company clients to use free zone companies to obscure the payment audit trail, and the beneficial ownership or even the management of an entity. So, and in doing so, they would conceal their involvement in potential money laundering activity. So as such, the companies that would not be caught by the federal legislation are subject to the full range of DNFPB's requirements, and they must implement an AML compliance program in their internal operations. Okay, so unlike onshore entities which do not have DNFPB's classifications on their trade licenses, under the general prohibition of the RACES DNFPB regulations, RACES companies may only carry out DNFPB's activities if they are specifically licensed to do so, and that's very important. So if we now look at the risk-based approach on the next slide, the risk-based approach is the measure that is used, as you know, by regulated entities to determine the most appropriate response from an AML perspective. So whether that is streamlined processes to enhance business viability in low-risk circumstances, or management of risk through application of enhanced measures, or in some other circumstances, complete refusal, to participate in a business relationship due to a very high risk, and also an inability to obtain comfort around the integrity of a transaction. So as is suggested by the range of outcomes, this process is contingent on factoring in a number of variables and is absolutely vital to businesses implementing an effective AML system. So there are several factors that are, as you can see on the screen, most commonly considered in a risk assessment for AML purposes. A, client risk deriving from the customer base and their activities. So for example, is the business activity in question commonly associated with elevated risk of money laundering or exposure to criminal activity? Then you look at countries or geographic areas in which it does business. So several countries are identified by various international bodies and watchdogs for being at a high risk for money laundering activity. This can be linked to inadequate, let's say, legislation controlling AML activity, or prevalent civil conflict leading to poor rule of law, or also close geographic proximity to countries subject to trade restrictions. As you know, when you look at the geopolitical map, this applies, or even probably like countries that are known for having particularly opaque banking provisions. The next important point relates to the products, services, and activity profiles. And then you also look at the distribution channels and the business partners. An important point also to mention is the complexity and the volume of its transactions. Would it be easy or difficult to obscure illicit financial flows within the standard financial activity of the company? Could this complexity be used as a disguise to conceal illicit transfers? So those would be the type of questions, that one need to ask himself. The use also of new or developing technologies for both new and pre-existing products is very important. I mean, we are at this era where technology is key, so it's also a very important item. So the risk assessments, including the factors above, are used to inform the development of new products, the changes to the business profile of company, and its management of its customer relationships. So the risk-based approach is fundamentally intended to provide regulated businesses with the means to manage their risk, as I said earlier, rather than avoid it completely. So as the world's attention has been drawn to the monumental fines attached to financial crimes, particularly when it comes to corruption offenses, but also sanctions circumvention, there has been a marked trend in the financial services industry of de-risking, an approach that essentially involves, as I said earlier, the complete avoidance of risk rather than risk management. And that's even something that was brought to the attention and was also discussed in one of the MENA FATF plenary sessions in the past. So although taking a risk-averse approach can sometimes be appropriate, the de-risking practices are typically applied at the expense of understanding the nature and the underlying risk. And the financial system is effectively closed off from actors who may be legitimate ultimately, so This is very tricky, and this has as a result, of course, you can imagine that this has a real life cost, not only for businesses that find themselves frozen out of the financial system despite being entirely legitimate, but only on a much larger scale in poorer countries where financial exclusion is major and large populations are entirely precluded from accessing the financial systems. So if we look at charities and humanitarianism, it provides a prime example of this phenomenon. And despite the universal exemption of humanitarian goods from sanctions restrictions, I have seen in the past, and we have had situations where banks had applied de-risking practices, and that had, by regularly refusing to make any remittances to restricted jurisdictions, even where trade was or is exempted from sanctions. So if you look at food and medical supplies that are disparately needed by populations in these countries, I mean, they are unable to get through because of, I mean, they are not able to get through the trade restrictions, and the populations there in the direst need are hit the hardest in times of crisis due to the de-risking approach applied by the banks. So the risk-based approach, when applied effectively, is intended to eliminate this sort of practices, although fear of punitive action by the authorities has somewhat determined perfect implementation. So I would put a disclaimer here, it's not a perfect system, and I think that there's always room for improvement. So the other point I would like to mention here, which is very relevant to the audience today, is the customer due diligence and politically exposed persons. So I'll move to the next slide. So the primary objective of customer due diligence provisions, CDD, is to ensure that regulated entities are able to actually identify their customers and parties to transactions, and where relevant, effectively prevent flows of funds to and from individuals or entities that are subject to restrictions around their financial conduct. Okay, so this in practice may result, may be the result of international measures such as inclusion on a list of designated nationals subject to a multilateral sanctions regime, if we look at OFAC, etc., or domestic measures such as an asset freezing order pending a criminal investigation. So the CDD measures are considered to be really the heart of AML and CTF frameworks due to the central importance of identifying high-risk customers and activity, and again, in informing prosecution efforts following investigation. So the CDD standards have evolved significantly over recent years, and regulated entities are now faced with higher requirements in terms of conducting risk-based assessments and obtaining a greater information about customers and conduct. Okay, so as an overarching obligation, regulated entities are prohibited from keeping anonymous accounts or establishing business relationships with entities and individuals where they are not able to complete the CDD requirements. And this is reflected in the RACE's DNFBP's regulations, which clearly prohibit all business relationships where the customer identity cannot be verified, and prohibit RACE's DNFBPs from dealing with shell companies or companies that utilize like pseudonyms or aliases or omit the correct customer name. So where a regulated entity is unable to carry out the CDD checks for whatever reason, they must decline to commence business relations and should file also an STR in relation to the customer. And this is very important. The specific requirements for CDD vary, of course, between circumstances and different types of customer and services. So in line with the findings of the risk-based assessment, you have, and as you can see on the screen, the simplified and enhanced due diligence measures can be applied to low and high risk customers respectively. So typically, the following CDD checks must be carried out. So identify the customer irrespective of legal form and frequency of activity, and verify the identity against reliable and independent verification data. Then the other thing is verify that any person purporting to represent a customer is authorized to do so, and separately identify and verify that person as well, okay? You need also to identify the beneficial owner and take reasonable measures to verify the identity of the beneficial owner using the data from a reliable source to obtain a satisfactory level of comfort as to the identity of the beneficial owner. And then you would need to due diligence on the business relationship. So by this, I mean, like to give you some examples. So the transactions, to ensure that they are consistent with the customer's profile, the business, and the risk assessment, and where necessary, the source of funds. So just to give you an example, I have been working on a major typology. It was an AML typology that had been identified. And one of the things that when we look into the files, the evidence, the data, etc., one of the major loophole that was identified was on the CDD side of things, where like the suspects were able to register companies, and they had not provided sufficient elements in terms of their own profile, in terms of the business activity, and there was a huge gap between the business activity as mentioned in the opening of the bank accounts, etc., whereby they would limit the trading activity, or the turnover was supposed to be limited to let's say $1 million, when ultimately, as a result of the AML typology, the suspects were able to have a turnover like of above 50 million dirhams. So we were from 1 million to 50, and this is, as a matter of fact, as a reason, like the reason, it was also based on the lack of CDD being undertaken properly. Okay, similarly with the source of funds. So the other point that is also very relevant is the making sure that the data is updated during the CDD process, and in particular for high-risk customers. Okay, so the RACA's regulations prescribe a set list of documents that need to be obtained for both natural and legal persons, which critically need to be obtained from, as I said, a reliable source. So this doesn't mean that all documents need to be obtained from third parties, meaning not the customer, but rather that they may need to be issued or legalized by a government agency, for example, to attest their authenticity. Because again, cases that involve money laundering activities do involve also forgery of documents, and sometimes you end up realizing that you have been provided with forged documents, or forged documents that were not legalized by a government agency. So you want to give yourself the additional level of support. Okay, so the CDD verification process should be ongoing. So existing customers should be required to update their details if they change in the course of the business relationship. Okay, as I mentioned before, where the risk-based assessment indicates that the customer poses elevated risk of money laundering, enhanced due diligence measures should be applied. And for example, this might include more frequent updates for the customer and the beneficial ownership information. It could include subjecting more of the customer business activity to the approval of a senior manager, so that activity is subject to a higher level of scrutiny, particularly in relation to examining transactions for indicators of suspicious activity. So likewise, simplified measures can be applied in instances where there is lower risk. So in reversal of the measures I just mentioned, this could include verifying the identity of the customer and the beneficial owners after the establishment of the business relationship instead of before. Okay, or in any event, less frequently than customers with more concerning risk profiles, despite the presence of typical triggers for CDD refresh. Okay. Now, where there is a suspicion of money laundering or terrorism financing activity, and the reporting entity reasonably believes that performing the CDD process will tip off the customer, they can file an STR in place of completing it in the CDD process, okay? So one point to mention briefly here is the response required when a CDD check reveals that a potential customer is a politically exposed person, or PEP, as they are more commonly known. This label is typically applied to any individual that has assumed public offense in any country of a sufficient rank that they may have been exposed to elevated risk of corruption or criminal activity. This can include military officers, it can include senior politicians, it can include also ranking members of the judiciary, and even sometimes prominent managers for international organizations. So in many cases, including for RACE's regulations, the definition is considered to include the family members of such individuals, the former occupiers of such officers, rather than active, and non-associates of PEPs. So associates is a loose term, of course, but any common ownership structures in businesses that favor PEP is likely sufficient to bring co-owners within the PEP definition, okay? So here I want to insist on one point, or highlight one point. One mistake that is made very often is that the label PEP in itself is not sufficient to indicate that a customer relationship is high risk and should be avoided as a result of that. So particularly if you look, I mean, in this part of the world, and in particular the GCC, many nationals who rank highly in society play quasi-public roles. So, and they are more likely to fall within the definition of a PEP due to the nature of the familial ties and the ruling structures that we have, you know. So there are many public officials within private family businesses interests that pose very little to no risk actually to regulating institutions, provided, very important, provided that the accounts are managed properly. So we have seen situations in the past where the PEP label has been used as leverage by some companies to assert that a business relationship is no longer viable or is costlier to the counterparty purely by virtue of the banking restrictions that are applied to all PEPs. But this is not strictly the case, okay? So whilst the PEP designation can carry additional internal compliance obligations, these are not borne by non-regulated commercial counterparties. And it is not a label for businesses to hide behind to avoid, as I said, a commercial relationship or to exert leverage. So in the first instance, I would say that the presence of a PEP in a customer relationship should flag the regulated entity to the presence of potentially eventual elevated risk, and the required responses should be applied accordingly. So if we look now at the DNFPP's regulations, it prescribes additional requirements for all dealings involving PEPs, okay? So where the customer or the beneficial owner is a PEP, approvals must be obtained from senior management in all cases. So enhanced ongoing monitoring should be conducted where the PEP is a foreign official, and reasonable measures must be taken to establish the source of funds, of course, and the wealth of PEPs. So obviously there is no set definition for what constitutes reasonable measures in these situations, but the available documentation in this will really depend on the claimed source of wealth. But the critical point I'm trying to make here is that we need to be able to demonstrate that there has been an attempt to connect the funds with a legitimate financial interest. Okay, now if we move to another very important topic, the beneficial ownership. So beneficial ownership, there is a relatively new requirement under UAE law that companies must disclose their beneficial ownership information, which was brought about by implementation of UAE Cabinet Decision number 58 of 2020 and came into effect last August 2020. Okay, so the purpose of filing UBO information ultimately is, I mean, simple. It's to assist the UAE authorities in enhancing corporate transparency and developing, again, the effective regulatory mechanisms in respect of beneficial ownership data. So under the law, and as is reflected in RACE's regulations, the threshold for beneficial ownership is set at 20%. So what does it mean in practice? In practice, it means that for every natural person that owns or controls jointly or independently 25% or more of a RACE's company, a client, of a RACE's company client, the DNFBP must obtain and verify identifying documents and information. So where no natural person fulfills these criteria, then the natural person fulfills, who has control over the company is considered the UBO, okay? So separate requirements are specified where the customers are legal arrangements, okay? So incidentally, the creation of this unified beneficial ownership database follows similar requirements brought about the US at the beginning of this year. And you may have heard about those, hopefully. And they have introduced actually the most sweeping changes to the country's financial defenses. I mean, the US financial defenses since the Patriot Act. So like the UAE, UBO registers in the US will be accessible by law enforcement agencies, allowing them to access the information in the course of criminal investigations into activity like money laundering and terrorism financing. And this is very important, of course, for the purpose of the assistance that can be provided to law enforcement when it comes to criminal investigation and the one that we have seen in the past and we have experienced, okay? So the RACE's regulations provide exemption for obtaining this information where the information is publicly available and the controlling interest is owned by a listed company or a subsidiary that is majority held by the shareholders of the holding company. So, and I'm sure, I mean, obviously you're familiar, very well aware of the RACE's regulations as this is where you operate, but I think it's relevant for me to highlight these points. So the suspicious transactions, the filing of suspicious transaction reports is also a very important topic. So if you look at and I'll move to the next slide, Joe, thank you. If we look at the international standards that are imposed by the FATF, it requires that states impose a direct mandatory obligation for regulated entities to report to their respective financial intelligence units all instances where they suspect that funds are the proceeds of criminal activity. And the UAE, obviously, is no different in this regard. So the designated FIU in the UAE is an internal division within the UAE Central Bank, which is responsible for receiving and investigating all STRs filed by regulated financial institutions, DNFPBs, and other reporting entities in the UAE. So all regulated entities have a mandatory reporting obligation to file STRs directly on the Go AML portal of the central bank, of the UAE Central Bank, which is a centralized system specifically designed for the submission of such reports. So this requirement is emulated in the RACE's regulations, where you will likely, already be aware that DNFPBs are required to impose indicators or suspicious activity and report directly to the FIU all instances where there is reasonable belief that transactions are related to criminal activity, okay? So bottom line is that professional or contractual secrecy cannot be invoked to circumvent this obligation, and there is no numeric threshold, you know? So in other words, the total of the funds under suspicion is irrelevant here, and the positive reporting obligation subsists regardless. So given the importance of STRs to the overall transaction monitoring system, it's important that STRs are of high quality, that's very important, and contain the right information. As I said earlier, filing an STR just for the sake of saying that I have filed an STR and ticking this box is of no help and is not, I mean, appropriate, you know. Although companies can be adept at identifying red flags for suspicious activity, very often this does not translate into finding the right kind of information in STR formats. And best practice, really, to help the law enforcement and the authorities, best practice is to include the key information, and just like the following type of information I will take you through. So whether the suspicion is related to money laundering or terrorism financing, whether the funds subject to a freeze are subject to a freeze order or potential freeze order, the related STRs previously filed on the individual, there were actually previously filed STRs on the individual and or the entity which is the subject of this STR. The relevant facts about all parties facilitating the suspicious activity of transactions, all involved accounts and transactions in chronological order by date and amount. And also, of course, the details of the reporting entity's position that the activity or the transaction is illegal or suspicious. By all means, if we are able to provide the necessary level of information and to do it in a professional manner, that can only help you, but also help the authorities ultimately, help you vis-a-vis your responsibilities, vis-a-vis your respective regulators, etc., but also assisting at a higher level the UAE authorities, okay, to strive for best practices. I'll move now to the next slide, which is about the record keeping requirements, because this is also very important. So record keeping requirements, they are imposed, I mean, ultimately to ensure that that there is sufficient data and financial intelligence available to provide a complete account of customer identity and activity in the event that they become the subject of an investigation, you know. So by imposing a minimum terms for the maintenance of this data, additional protections are applied against loss of evidence, of course, because it's all about the ability to retrieve and to provide the necessary level of evidence that would be used in turn by the authorities in due course. So DNFBPs must maintain all records, documents, and data related to transactions and operations for a minimum period of 5 years following the date of concluding the transaction or operation, or concluding a business relationship even. So I think it's very important for me to say that this period of 5 years is consistent with the 5-year term contained in the FATF standards and the UAE AML legislation, okay? So these provisions are also extended to all data records and documents obtained in the course of due diligence procedures as well, okay? So in addition to the account files, business correspondence, and all results of any conducted analysis for a minimum of 5 years following the termination of the business relationship or after the date of an occasional transaction. So the investigative rationale behind this provision is apparent in the requirement that, as I said, records should be sufficiently detailed to permit data analysis and tracking of transactions. Essentially, it should be possible to identify, confirm, and provide information to the authorities for all business activity and transactions carried out by a customer. So if you recall the example I mentioned earlier about this AML typology and where we have assisted the UAE authorities to conduct the investigation, I mean, we had with the client to go back to like the history, and it was, of course, obviously a positive point and extremely helpful that we were able to have the 5-year history with all the transactions and the business activity, because for the purpose of the AML, I mean, this typology and what had been identified, the data analytics was key and was crucial for the FIU and then for the law enforcement, okay? So DNFBPs are also required to provide all recourse to the competent authorities, so including here RAKE's authority, immediately on receipt of a request for information. And that's very important, of course, because the need for expedient response shows the importance that is attached to AML and CTF investigations conducted by domestic authorities. Okay, so there is another thing which is very relevant to mention here, is that there is currently what we have seen as a trend. I will briefly mention it, but the conflict between data privacy and information sharing is shaping up to be one of the defining features of the fight against financial crime. And a lot hangs in the balance as it is debated in like policy circles around the world, you know. But it's still very important that, I mean, to do your part of the job, if I may say so, you are compliant and you comply with the regulations that apply to you. So now if we move to the red flags for suspicious activity, when it comes to red flags, there is often, I think, a misconception that as soon as we have a single suspicious indicator, that is sufficient to think that we have an instance of criminal activity, but this is not the case. So often we are looking, what we are looking for actually, and even when we are providing assistance to our clients, whether at the investigative stages or even when there is an actual case, there are like some indicators or behavior that cumulatively point towards one of two different things. Either, I'd say, the pattern of facts or red flags would match a certain typology that has been identified as being a commonly used methodology of money laundering or terrorism financing, or when taken together, the red flags overcome any logical or sensible rationale that could reasonably be used to explain the activity. Okay, so the other important thing to note is that the red flag system is not infallible. You know, one of the main issues that the financial crime compliance system has to contend with is the fact that in the overwhelming majority of instances, criminal activity is not possible to spot on the face of a transaction. So general factors are diverse and can arise in circumstances around the transaction in question. So these factors would range from there being unexplained urgency in the transaction, or the customer being reluctant to share information about the transaction, or appearing to be operating on behalf of a third party, but is reluctant also to disclose this information, you know. So it could also involve more conclusive factors, such as when you become aware that there is an active investigation into the customer, or there is public record or connection of the customer with criminal activity, okay? So more specific red flags can arise in relation to specific points of the AML process or aspects of the transaction. So knowledge, for example, so I'll give you a few examples here. Knowledge of reporting or record keeping requirements. So for example, the customer may appear to be structuring the transaction to avoid record keeping or the reporting thresholds, okay? Other example would be on the identity documents. The customer would provide doubtful or vague information, or he would produce or she would produce documents with different legal names. Another example, when it comes to economic purpose, the transaction is unnecessarily complex for its stated purpose, and the activity also is, let's say, inconsistent with what would be expected from declared business. Okay. The other thing I can mention here is the transactions involving areas outside of the domestic jurisdiction, like, let's say, transaction that would be in a country, or involving a country known for highly secretive banking and corporate law, or let's say where illicit drug production or exporting may be prevalent, or where also there is no effective AML system, you know. So I'm skirting around the edge of the sanctions issue here because that topic is one that will also require an entire dedicated session, which today I won't have time to cover. But for the sake of completeness, I'll just say that activity in sanctioned countries is a significant red flag for illicit activity, okay? So sanctions are ultimately tools for political leverage, which means that they are not applied consistently across the international system. And in the UAE, the United Nations sanctions are implemented by all natural and also legal persons as a matter of law, and foreign sanctions such as those that are implemented by the US or the UK authorities, and certain commercial free zones as a matter of best practice. Okay, so RACES requires compliance with all major international financial sectors, which means that companies need to ensure that their screening methods that are operating in restricted jurisdictions, or whether or where they themselves may be designated entities or individuals. So another example I would mention here is actually the transactions that are related to offshore business activity. So transactions involving an offshore shell bank whose name may be very similar to the name of a major legitimate institution. This is something actually we have seen and we see repeatedly, not only actually in money laundering cases, but also fraud and embezzlement schemes or cybercrime type of cases, where the perpetrators hope to conceal changes in account details behind closed matches, okay? And it does frequently happen. So of course, all this is a non-exhaustive list, but I think hopefully it gives you a good idea of what the various indicators might be. Okay, so ownership of AML compliance. The final here very brief point I will mention is the need to have an internally appointed compliance officer who is responsible for overseeing the implementation of an internal AML compliance program, and is ultimately accountable for its effectiveness. I mean, it's one thing to have the policies. If you don't have a compliance officer, it becomes a tricky exercise as well. And the federal AML legislation refers to this role as the money laundering reporting officer, MLRO, who is not only the individual tasked with submitting STRs to the FIUs, but is also responsible for overseeing the overall functioning of all AML policies and procedures. So here, this role is not that of a regular employee, if I may say so. Individuals who are designated as MLRO have specific regulatory obligations and can face liability if these obligations are breached. So if the let's say if the internal compliance function is outsourced to a third-party service provider for any reason, which I wouldn't encourage, this liability is not avoided, you know. And supervisory authorities, including RACES authority, have powers to leverage enforcement powers in the event of all breaches. So to wrap everything up now, I hope I have given you an overview of how the the UAE's AML framework is intended to operate in practice, and how at the company level these controls can manifest in quite nuanced and complicated requirements. So despite the seeming complexity, the overarching consideration should always be the utility of the AML monitoring framework, and what action would be most appropriate to protect the UAE's financial system, you know. So this is not always making the risk averse decision, but rather it is a sensitive risk analysis approach that I encourage, where the risk levels are managed with adequate and robust controls at all points where the system is vulnerable to abuse by criminal actors. Supervising this system is clearly, I think, a monumental task and requires a perpetual effort to find more efficiencies and effectiveness. And of course, one very important point nowadays, technology is providing, of course, some of the answers, as are also partnerships. And it's likely that we will see the authorities, the UAE authorities, exploring their options in these areas over the years to come. I mean, there were a lot of details thrown out today, so and maybe a lot of things to digest, even though hopefully you're quite familiar with most of the things I have addressed because of your knowledge and implementation, full implementation of the applicable regulations, the RACES for the within RAC and RACES authority. But if you require assistance, either in a state of crisis, hopefully not, but it does happen, or if you simply want to take preemptive action to make sure that your policies within your respective companies and the procedures are in line with best practice, are up to date, and the staff is regularly also trained, then please, I would say, do not hesitate to contact me. I can see that we have quite a lot of questions that have just come through. I think we are short on time because I have run over, but I will be happy to cover this by email after the session to the people that have posted them, because they are quite specific, you know, and I'm afraid I will have to stop talking for today. But I would like to thank you all very much for your time, and hopefully you found this session of interest. Thank you very much, and Lana.
Thank you, Ibsam. Really appreciate you taking us through not only what we need to do, but also why we need to do it. And I think that's really important and extremely valuable. In closing, I just wanted to take the opportunity to emphasize what you've just said about getting a third-party review of what you're doing, because as our registered agents will know, we've already started an inspection regime whereby we look at the compliance of the DNFPBs with the regulations. And obviously our job is made an awful lot easier if agents have had a look at that before we get there. And I would say it's not a bad idea to have that third-party review before your regulatory authority comes knocking on the door. In terms of what we've been finding so far with what we've been seeing, many registered agents have good, effective working practices in place, but they haven't got them documented. So they haven't documented their formal governance, their processes, their procedures. So when we come in to look at what's being done, it's actually difficult for the registered agent, the DNFPB, to evidence it. And so the message there is your regulatory authority is going to come in and they're going to want you to prove that you're doing the right things, and good documentation and good evidence is going to help you do that. Another area that we've seen is still developing is training, both of compliance staff, but also all staff. All staff have a role in AML-CFT, so please don't just leave it to the compliance department. Training should be across the organization. We've seen some gaps on risk assessments, and Ibsam has gone through the need to do the risk-based approach and how you risk assess your clients. So again, evidencing that is very important. Ibsam also mentioned the requirement to file STRs, and so again, we'd encourage everybody to be registered with the central authorities so that you can make those filings. It would be remiss of me today, it's not the topic of this conversation, but I want to make the point that ESR filing deadline 30th of June is coming up. And as part of your compliance responsibilities, please ensure that all of your customers that have had economic substance requirement relevant activities up to the 31st of December file their notifications by the 30th of June. And I've already noticed that the system is slowing down a bit. So please don't leave it till 11:59 p.m. on the 30th of June, because if you do and the system doesn't accept it, you'll get a penalty for late filing even if you were trying beforehand. So just a word of caution for me on economic substance. I know not the topic of today's conversation. Very, very grateful to Ibsam and the Al-Tamimi team for putting this on for us. It's helped immensely. We're very much engaged in ensuring that there is compliance across the UAE. We're feeding into the Moneyval, the FATF assessments, and doing everything we can to put the UAE in the best possible position. And it's definitely a team requirement from the regulatory authorities, from industry, and from your clients. So I'll leave it at that. Just very grateful to you for your time today, and very grateful for everybody for joining. Thank you.
Thank you.